can hear you, Sir David. Oh, you're gone again.
Try now.
This is perfect. Yeah.
You can hear me?
I can hear you now.
Oh, that's a relief, because what I've actually done is switch the microphone off. Thank you. Let me just shut the door, if I may. You're rather faint. Is there a way of adjusting the volume at all?
Can you hear me now?
Yeah, I can. Yes, that's better.
All right. So, Sir David, we're ready to kick off on this end. I'm just going to read out a preliminary statement. I'll ask you to confirm the situation, and the legal representative here today as well will confirm. That's all right?
Of course.
So, the sitting of the DIC court is taking place in Dubai, although the Deputy Chief Justice, Sir David Steele, as the judge hearing the application, is appearing in Dubai by means of video conference in London. Any orders made in the course of or at the conclusion of the hearing will be made on the Deputy Chief Justice's instructions by the registry in Dubai. Will both the judge and the legal representatives kindly confirm that they are fully aware that the procedure is as I have stated above? Sir David?
Yes, that's very satisfactory. Thank you, and fully understood.
Mr. Abu?
Confirmed.
Mr. Barrett?
Confirmed.
So good morning all. We're here for a hearing in the matter CFI 26-2014 before the Deputy Chief Justice, Sir David Steele. The applicant is represented by Squire Shabbat. The counsel is James Barrett. Assisting is Elaine Farhad. The respondent is represented by Clifford Chan. The counsel is James Abbott. Assisting is Shane Burry.
Thank you. Well, Mr. Barrett, it's your application, I think.
It is indeed, my Lord, yes. My Lord, it's our application for a stay of proceedings pursuant to Article 60 of Federal Law 10 of 1973, which, my Lord, for convenience, I think all parties will call the USC law. Does your Lordship have before you a copy? Should have before you a copy of the hearing bundle, a separate bundle of authorities served by my learned friends the other day, and also copies of the parties' respective skeleton arguments.
Yes, I have all of that. I'm grateful to both of you for your skeletons, which I've read, and I have looked at quite a few of the documents to which they refer. So I have done my homework.
I'm grateful for that indication, my Lord. In those circumstances, perhaps if I may outline how I intend to structure my submissions. I plan to first summarise very briefly the procedural background. I say briefly because, of course, as your Lordship knows, you requested us helpfully to prepare a chronology which I think usefully sets out the matters. I will then move on to the question as to whether Decree 19 of 2016 requires that a judicial authority, rather than the USC, determine any conflict of jurisdiction. And then the third issue will be the question of Article 60 of the USC itself, which breaks down, we say, into two questions. First, and this will be, as your Lordship will imagine, the bulk of my submissions, is there a conflict of jurisdiction? And secondly, has a petition been filed with the USC? I think the latter one we can deal with briefly. And then finally, my Lord, I may, in summary form, address the suggestion that this application is itself an abuse process, though depending upon how your Lordship wishes to deal with matters today, that may be best left to apply. So, moving on then, my Lord, to the first issue, which is briefly outlining the procedural background. Your Lordship will see there's a summary of my skeleton argument of paragraphs 3 to 5 and the course of chronology. I don't obviously intend to read that out, my Lordship, but suffice to say, your Lordship is already familiar with this case, of course. It was commenced by way of a claim form on the 6th of April, August 2014, which one can see from the first entry in the chronology. shortly thereafter.
So when you're referring to the chronology, what are you referring to?
I'm referring to the document, my Lord, and I apologise if you don't have a copy before you. You requested, my Lord, that the parties prepare a chronology, which I understand
Yes.
ought to have been delivered, but I'm not sure whether your Lordship...
No, I'm afraid it hasn't reached me, but I have, I think, constructed my own chronology, so because it hadn't turned up. So don't worry, I have a feel for the dates.
I'm grateful. In which case, it's simply to say that we commenced an application, we sought an application to stay proceedings some 18 months or so ago now. Your Lordship dismissed those. We subsequently appealed those to the Court of Appeal, which rendered judgment in ICPL against us. And it's just right to very briefly say, as your Lordship knows, because I think it's relevant to my learned friend's argument, the claimant's particulars of claim were filed in February this year, and a defence was filed on the 6th of April, and the claimant's reply was filed on the 18th. It's fair to say that the claimant also filed an application for immediate judgment on the same day. So the point I'm making then was that progress has been made to an extent on the substantive claim. This application, your Lordship, of course, knows about. I don't intend to take you to the application itself, but your Lordship will see there from paragraph 5 of my skeleton, the application was filed on the 9th of June. The claimant filed an answer, and by consent, my Lord, the parties were given permission to adduce expert evidence. We filed a report of Dr. bin Hazim, and the claimant filed a report of Dr. Habib al-Mullah, who, in fact, my Lord, it's fair to say, is actually in court today, sitting behind my learned friend. As your Lordship knows from the previous application, proceedings were brought by us before the charge reports, which dismissed the case on the basis of lack of jurisdiction, and that was upheld subsequently. The basis of the charge report's reasoning was that since the claimant carried on business in Dubai, the Dubai courts and not the charge report had jurisdiction in the matter, my Lord, and it's on that basis we say that the defendant commenced proceedings in the Dubai courts, seeking the same relief effectively as sought in the charge proceedings. And my Lord, just briefly give you the chronology of that. On the 11th of April, we filed a claim before the Dubai Court Centre for Amicable Resolution of Disputes. Following this, the substantive claim was filed before the Dubai courts themselves on the 30th of May this year, and there's been a jurisdictional challenge in the matter, and it's those proceedings which we say give rise to the pending proceedings of the conflict of jurisdiction. On the 24th of July, my Lord, we, the defendants, issued an application in the Dubai courts requesting that they stay their proceedings, much as we have done in relation to the present application. We had understood, my Lord, that the Dubai court was listed to render judgment today, in fact, which formed the basis of our request that this hearing be adjourned, though I think it's fair to say at the bar that there's some uncertainty as to whether the Dubai court will in fact render judgment today or at a later date. I think that's the tenor of my learned friend's point on that, and we agree with that. My Lord, that then...
Forgive me for interrupting. The application for a stay that was made by you on the 9th of June in the Dubai courts, I'm so sorry, that's the wrong date. The application made by you on the 24th of July in the Dubai courts, pursuant to Article 60, is an application to stay your own proceedings, is it?
It is, my Lord, yes, it is. And the rationale for that is, we say, and of course I'll come on to this, is that as there is a conflict of jurisdiction between the DISC courts and the Dubai courts, it's only appropriate that both proceedings be stayed, which we say is something that is in fact mandated by the text of Article 60 itself.
Right. Just going back to the beginning of the story, the claim was originally taken out in the DIFCC on the 6th of August 2014, and that was matched by a claim by your clients in Sharjah on the 12th of January, correct?
That is correct, my lord, yes, that is correct.
Yeah. And there was no suggestion at that stage that there was some conflict of jurisdiction between Dubai and Sharjah, which would engage Article 60.
That is correct, my lord, but I think the point we would make is that once that claim was commenced before the Sharjah courts, which were commenced because that's the location as to where the defendant's place of business is, which is why they were commenced in the Sharjah courts, once the Sharjah courts directed that any proceedings must be determined in Dubai, we then proceeded with the Dubai proceedings, or the Dubai action as we've both defined it. And it's then, my lord, that I think it's fair to say, of course these are questions of UAE law, it's obviously matters that local council and ourselves have been on. It's then that we appreciated the need, given this conflict of jurisdiction, to make the application to the Union Supreme Court. I don't know if that answers your lordship's question. So, my lord, that then brings us to the petition itself, which I think we can helpfully turn to, which is defined at the bundle, my lord, at tab 8, page 75 onwards. And your lordship will see there, this in the top left-hand box, that it was filed on the 6th of June 2016 from certified translation. And if your lordship turns a couple of pages in the same tab to page 77 of the bundle, your lordship will see there a recitation of the procedural background to the case. And if your lordship looks towards the bottom of the page, paragraph 3, you will see there the document explains that the plaintiff in turn lodged an accounting claim before the Sharjah Civil Court, seeking recalculation of the interest payable from the due amount based on the parties. And it continues, my lord, if I may. It further sought to oblige the bank to pay compensation to it in the sum of 200 million dirhams for the damages it suffered as a result of the plaintiff's bank's breach of the terms and conditions set forth in the parties' agreement. And my lord, that's important, we say, because the claims that were commenced in the Sharjah Civil Courts and subsequently in the Dubai action are not simply carbon copy claims, such as have been advanced by my learned friend's clients in these proceedings. They are themselves substantive claims, including claims for damages which we say the claimant owes to us, my lord. So they are positive claims. And my lord, if you briefly...
Well, can I understand the position? In the proceedings issued in Sharjah, and then, as I understand it, exactly the same complaint made in the Dubai courts, there is a issue about the calculation of interest, and there's an issue about the need for damages in the form of compensation up to 200 million dirhams, correct?
Correct, my lord, yes.
I mean, is it otherwise accepted that the loans are repayable to the claimants?
My lord, I think my understanding is of the Dubai action, and we've made the same points in pleadings in this case, is that the manner in which the claimant sought to collect interest and the way in which it allocated it in relation to the loan was itself a breach, which caused our client losses in that the value of the security subsequently fell, and that in turn meant that we were then unable to repay the loan in the same way which we would have been, we would say, but for the claimant's breaches of its express and implied obligations, both under the share pledge and under the parties' loan agreement, the 2009 and 2010 loan. Now, my lord,
But there's no cross claim for the 150 million.
My Lord, no. And the reason why there's no cross-claim, and we would say that these were matters which could quite properly be brought as a cross-claim, and we would say, I appreciate they made the argument, but we would say would give rise to an equitable set-off. The reason why there's no cross-claim, my Lord, is because we have pleaded in our defence that these were matters, particularly in relation to the share which need to be dealt with by the Dubai courts, rather than the courts for the DIFC. So
well, it may well be so, but as I understand it in the Dubai courts, you're still not making a cross-claim.
Well, my Lord, as I understand, we are making a positive claim. My name is Mr. Paddock.
Well, the positive claim is for 200 million, isn't it?
Indeed, my Lord, yes.
Yeah, but not for $180 million. Anyway, there we are. It's puzzling. Yeah, thank you.
Thank you. I'm grateful.
Yeah.
And if your Lordship turns a couple of tabs forward to tab 10, it reiterates the point, my Lord. You can see there. This is a summary of the claims as advanced in the case subject at the top of the page before the Dubai court.
Yes.
I need not read that out. And then briefly, just turning back to tab 9, again, just for certainty, your Lordship there will see the certificate of service. So, my Lord, having therefore summarised that, we can really turn then to the meat, as it were, of this question regarding the decree. And the question.
Before you turn to that, could I just ask one other question? The terms of Article 60 identify what should be attached to the petition, and what is required is official copies, I'm not quite sure what that means, of the disputed petitions or the contradictory judgments. So what is attached to the petition?
My Lord, my understanding is that what was attached to the petition, and these are obviously copies here, are, and you can see the exhibits, so we go to the petition itself at tab 8.
Thank you.
We can, just going through it, we can see the summary of the arguments, and just going to the back of it, where I ought to explain the attachments.
So where are you looking?
Give me just 1 moment.
Yeah.
My Lord, yes, if you go back to page you're on before, page 77,
Thank you.
your Lordship will see there at paragraph 3, paragraph 1 first,
Thank you.
to exhibit number 4 at the end, which attaches a copy of the DIFC full claim, and similarly...
Yes, sorry, let me... Yeah, okay, hang on one second.
My apologies, my Lord. Sorry.
So what's exhibit number 4 is the statement of claim in the DIFC proceedings, correct?
Correct, my Lord, yes, correct.
Yes.
And then at paragraph 3, at the end, your Lordship will see exhibit number 5, which is the claim before the Sharjah court.
So what is said to be, I don't know whether they're official copies, let's assume they are, what are said to be the disputed petitions or contradictory judgments are the 2 statements of claim.
Indeed, my Lord, but not only, because if your Lordship turns over the page, your Lordship will see at paragraph 5, it also exhibits your Lordship's order, which is referenced to be exhibit number 6 in the present proceedings, or at least decision of the Court of Appeal. I don't have a copy of the exhibits here, my Lord, but I do understand that our local counsel, Mr. Ali Aldabas, will be here later, so perhaps he can confirm that for us. But your Lordship will see there...
So exhibit number 6 is what?
Is
the application to appeal to the DIFC Court of Appeal?
It's not clear, my Lord, is the answer. It would appear to be the application to appeal.
Right.
Okay,
thank you.
Exhibit number 7, my Lord, which you can see at the bottom of the page, the exhibit number, is...
Yeah.
is a decision of the Sharjah Federal Court, I believe. And, my Lord, over the page, paragraph 7, exhibits 8 and 9 are the...
Sorry, exhibit number 7 is what?
I believe
The merits... Is the judgment handed down by what? The Court of Cassation or the Court of Appeal or what?
It's the original Sharjah Court, so the Sharjah Court of First Instance, I believe.
Oh, right.
And indeed, that must be right, my Lord, because if you turn the page 79, paragraph 7, exhibits 8 and 9 are the decisions of the...
Okay, understood.
Understood. And then, my Lord, you'll see paragraph 8, exhibits 10 and 11. There's also exhibited the decision of the DISC Court of Appeal.
Thank you.
And similarly there, exhibit number 12, which is the reference to Dubai Court's action. So, my Lord, the point there, assuming these were official copies, is that all of the details of all the proceedings have been brought to the attention of the UN Supreme Court in the petition.
Thank you.
And also, if I may turn then to what we say is the first issue, which is the question whether or not the decree requires that the judicial authority established by that decree is now the sole authority to determine any conflict of jurisdiction between the courts of the DIFC and the Dubai courts. My Lord, the claimant's case is that the judicial authority is now the sole body. And we agree, my Lord, we agree that going forward, prospectively in relation to new claims, that is indeed the sole body. The question in these proceedings is whether or not also that legislation also has retrospective effect. So, my Lord, if we can perhaps turn to the decree itself, which is at tab 11.
Okay.
And at tab 11, your Lordship will see certified translation of the decree. And if I may just indicate, my Lord, it explains that the decree establishing the Dubai and Dubai Financial International Centre Court Judicial Authority. In the recitals, there's reference to both Dubai and federal law, and also reference in Law 12 of 2004 of laws of the DISC. And similarly, my Lord, moving to the bottom of the page, in Article 1, there's reference to the composition of the judicial authority, i.e. who will sit. And again, it's a combination of the Dubai and DISC courts. My Lord, if we move forward a couple of pages to page 106 of the decree, your Lordship will see, and I just raised this now as we're here, at Article 4, which deals with conflict referring to the judicial authority. And, my Lord, looking at the initial sentence, it reads, in case of any conflict of jurisdiction between Dubai courts and DIFC courts, that no court relinquished hearing the case, all courts relinquished hearing the case, all the courts rendered conflicting judgments in such a case, the following shall apply. Now, my Lord, we say, and I'll come on to this in more detail within Article 60 as well, but we say these are separate categories. And the way we see this, my Lord, is by the use of the list with the word or at the end of it. So if one reads the sentence again, if I may indulge you, my Lord. In the case of any conflict of jurisdiction between Dubai courts and DISC courts, that no court relinquished hearing the case, comma, and then we say 2, all courts relinquished hearing the case, or 3, the courts rendered judgment in each case. Now, my Lord, we say, as a matter of ordinary use of language, or at the end would denote 3 alternatives. The first and second are antonyms, and the third judgments go either way. So, my Lord, that's what we...
Well, I follow that point. That's the point that you make in relation to Article 60, because the terms are very similar.
They are very similar, my Lord. The only difference being, and we'll of course come to it, the only difference being that Article 60, if anything, at least in the English, is stronger because it actually has two ors, rather than being a list. But I don't think there's much in that. And my Lord, we can, I will of course come to this later, if we perhaps turn the page for present purposes. Your Lordship will see there at Article 8, at the bottom of the page, entry into force and publication. The decree shall come into force as of the date of issuance thereof, and shall publish in the official gazette. And the date is just there in small letters on the right, 9th of June 2016. So the defendant says, the defendant says it's clear this has not come into force on until the 9th of June. Now, the claimant's position is that this is a procedural law, and it comes into effect forthwith, and indeed has retrospective effect. Here, my Lord, there is a dispute between the experts, and I'll take your Lordship to those in a moment. But in summary, the defendant's expert, our expert, Dr. bin Hazim, explains that pursuant to the UAE Constitution, legislation is not retrospective unless it says so expressly. And indeed, I understand that actually Article 112 of the Constitution itself says that, though I don't have a copy of that in front of me. I'm sure we can locate it if necessary. But unless it involves public policy. So that, my Lord, is the position of our experts. And if we could perhaps briefly turn to tab 6, page 47 of tab 6.
Yeah.
Your Lordship is ahead of me, as ever. Paragraph 7.4.7. Dr. bin Hazim, I'll let your Lordship read that.
Yes, I've read it.
Indeed, my Lord. So, and similarly, the point regarding vested rights at paragraph 7.4.8. So that, my Lord, is the...
What vested rights are you referring to there? Is the author referring to?
Well, vested rights in that the application has already been commenced. Now, my learned friend quite properly says the case is not one due for hearing in a matter of days. I accept that. But nonetheless, vested rights and obligations do accrue when an application has been filed, as it has been here almost some 2 months ago. Clearly, work and effort has gone into creating the petition, which your Lordship has seen. And further, given that a party, we say, under Article 60, once it's made its petition, given that all courts are mandated to stay, that is itself a vested right which a party has, or rather an obligation directed to courts. So it seems to us surprising, we would submit, that would be given retrospective effect so as to take away those rights.
Understood.
My Lord, and if we look at the contrary evidence of Dr. Habib al-Mullah, which can be found at tab 7, page 58.
Yeah.
My Lord, we'll see there at paragraph 15, there's a reference there to when it is a procedural law which is passed as opposed to a substantive law, that law has a retroactive effect by default. Paragraph 15, your Lordship will see that. And the expert explains also at paragraph 16 that Article 1A of the CPC, the Civil Procedure Code, establishes the rule that procedural laws shall apply prior to their entry into force. My Lord, and your Lordship will see there the excerpt from Article 1A of the CPC, which I don't intend to read out. Now, my Lord, there's an issue here in relation to jurisdiction and whether pleadings have closed in the case. Now, my Lord, we accept that pleadings have clearly not closed in this case at that time. I think that's obvious. My Lord, if you
Sorry, could you say that again? As I understand it, the pleadings in the DIFC action had closed in May.
My Lord, yes. Apologies, my Lord. I misspoke.
Yeah.
I misspoke. My apologies. I misspoke there.
So, assuming for the purposes of argument, and I'm not sure I'm making that assumption yet, that the CPC is relevant to considering the retroactivity or otherwise of the Decree 19,
Yes.
the question arises as to whether the effect of Article 1A is to apply to all cases, but in particular whether it applies to this case, where it's subsequent to the close of the pleadings in at least one of the courts.
My Lord, yes, in relation to matters dealing with jurisdiction, indeed.
Right.
My Lord, yes. May I just... My Lord, yes.
I mean, that might be in your favour, I suppose. Anyway,
I was going to say, yes. I was going to say, exactly.
Yeah.
But my Lord, as you'll see, the defendant's, sorry, the claimant's expert continues, my Lord, over the page of paragraph 18.
Yeah.
And your Lordship will see there, it explains that it's a procedural law within the meaning of Article 1 of the CPC. Now, my Lord, as your Lordship will have seen in my skeleton at paragraph 23, we say that the court should uphold the defendant's position in relation to this and prefer the evidence of with respect of Dr. bin Hazim if necessary. And we say so, my Lord, really for this reason. First, that the decree is not, in its terms, a procedural law relating to the civil law of the Union. Rather, it's a decree making express reference, as your Lordship would have just seen, both to the Dubai courts and also to the DIFC courts. The DIFC, as your Lordship is more familiar with than I am, is a separate jurisdiction, and laws passed by the ruler of Dubai in relation to DIFC courts are governed by DIFC law and not union law. And your Lordship will see there I've referred to a number of authorities which are not in the bundle, but it matters not, my Lord, because there will be reference when I turn to the main authority dealing with this, which is in fact the Court of Appeal judgment in IGPN itself, which is at tab 16, page 186. And the judgment deals with it in quite some length, my Lord, so I would just skim through relevant parts to give your Lordship the full context.
So just summarise the point you're making. Because the CPC doesn't apply, is that the point, or is something different?
Correct, my Lord, correct, yes. The CPC does not apply to DIFC, to the DIFC. And we say there...
Well, I'll accept that without further... I mean, that's a matter of statutory record.
Indeed, my Lord, indeed.
Yeah.
In that case, I'll move on from that, if your Lordship with me.
I mean, as I understand it, you make 3 points about the proposition that it is retrospective. First, you say, on the face of it, the Decree 19 is not a procedural law at all.
Yes.
Secondly, if and to the extent the CPC applied, pleadings were closed in one of the cases. And thirdly, the CPC itself being a federal law which is not applicable to the DIFC, then you can't use Article 1A, or whatever it is, 4A is it, to make good a proposition that it is retrospective.
My Lord, indeed. Indeed, exactly. And
Yeah.
they are essentially my submissions on the point of the decree. So we therefore say, applying ordinary common law principles, the legislation would not operate retrospectively, but would rather operate prospectively unless there were clear wording to the contrary, which is not the case here.
Can I just take you back just one moment to what appears to be the agreement between the experts to the effect that the Decree 19 actually precludes the USC from considering a dispute of jurisdiction as between the Dubai courts and the DIFC. And I wonder, I have to say, how it is said, I'm not sure it matters, but how it is said that a Dubai decree can actually amend a federal law.
Well, my lord, indeed, and in fact, just as your lordship was saying that, my learned friend, Miss Wellington, had indeed Dr. Alialdous, who's here as well, where they're pointing these issues out to me as well. And it does seem curious, my lord. Of course, I wouldn't wish to make any statement regarding what the rule of Dubai wishes to do. The point I would make, though, my lord, is it does raise questions as to how you could, how it would purportedly seek to take away a party's entitlement to make a petition pursuant to the USC law. I
mean, as I understand it, Article 33 of the law sets out the jurisdiction of the USC.
It does, my lord, yes.
And that includes a... thank you very much. That includes, under paragraph 10, or Article 10, the jurisdiction between a judicial authority in an emirate and a judicial authority in another emirate, or among the judicial authorities in one emirate. Now, as I understand it, if the experts are right, that has to be regarded as having been amended in some way with the addition of the words brackets, save in respect of Dubai.
My lord, yes, indeed, if the experts are right, yes. I mean, I think it's right to say, my lord, whilst there's agreement between the experts on this, we don't necessarily accept the correctness of the decree as
amending or ousting the jurisdiction of the Union Supreme Court. I mean, it may well be that the consequence of Decree 19 is that the Article 33, insofar as it refers to Dubai, becomes redundant, because applications in regard to jurisdiction will be dealt with by the committee, but I'm not at all sure it doesn't leave open the possibility of having another crack at the point in front of the USC. We shall have to see. This is a tricky and new area of the law.
It is, my lord. It is indeed, and I think there are real questions, as your lordship has, if I may say, rightfully observed, as to how this law will play out in practice. But I think we would say, my lord, a fortiori in relation to cases where there already is a pending petition before the Supreme Court. That it seems to us, my lord, would raise a whole host of questions in relation to the interrelationship between the ruler of the
Understood, yeah. But anyway, I must not disguise the fact that I have half an eye, if not a whole eye, to a whole range of other actions in the DIFC to which these issues may be pertinent.
My lord, indeed, yes.
So we have to be a bit careful, I think. Anyway, is that your point on retroactivity?
It is indeed, my lord, yes.
Yes, thank you. So let's move on to
Article 60.
To conflict.
Conflict of jurisdiction.
Yeah.
My lord, yes. Perhaps when you take into the text, as your lordship was just looking at, start with Article 60 itself, which is on...
I have that, yes, thank you.
And my lord, it's the same point as I made briefly about the decree.
Yes.
And your lordship will see there, as I made the point, I want to belabour it, the use of the two ors, that these authorities have not abandoned hearing of the action, or that all of the authorities have abandoned hearing of the same, or issued contradictory judgments thereon. My lord, so we would say that, if anything, even clearer than the language of the and your lordship has already noticed, of course, within Article 33, which we just looked at, that it's undisputed that there can be very briefly to 9 and 10 of Article 33, page 118, my lord. I'm keeping your finger on 1, 2, 3. the jurisdiction dispute between a judicial authority in an emirate and a judicial authority in another emirate, or among the judicial authorities of one emirate. My Lord, and I think it's right to say that's undisputed, that we fall within that.
Well, there's no issue about that.
No, my Lord, no, indeed. My Lord, so we say that in terms of conflict of jurisdiction, there are three separate limbs to it, my Lord. There's first, not abandoned hearing of the action. Second, all judicial authorities have abandoned hearing. And third, that the judicial authorities have issued contradictory judgments. Now, my Lord, I don't propose again to belabour it, but if there's contradictory judgments, that of course is a clear case of conflict of jurisdiction. We accept that. Similarly, if all judicial authorities have abandoned the hearing, then the Union Supreme Court is competent to decide it, lest the party would be left with no remedy. My Lord, that's also...
Now, both those examples require a decision of the authority, correct?
My Lord, well, indeed, in the event it's abandoned, yes, my Lord, and indeed...
Right, so the authority actually positively abandons jurisdiction or positively retains jurisdiction. So you say there is a third possibility, that the authorities have not abandoned the hearing, and as I understand your proposition, that means simply that where a court's jurisdiction has been invoked by a party, and that party has not abandoned his claim, another party has invoked another jurisdiction and not abandoned it, there is a conflict.
My Lord, yes.
Is that correct?
That is correct, my Lord. Say that I would add something to that. I would say that when a party invokes the jurisdiction of the court by commencing the claim, it is inviting the court to exercise its jurisdiction in favour of its claim. So, my Lord, what we are looking at here is not simply a party that can simply file a claim and then seek to invoke the petition before the USC. Rather, we're dealing with a situation where the legislation has said, if your Lordship is with me on there being three categories, which I think is the language. First, if there's a judgment which goes one way, well, that's one thing, my Lord. But then what does not abandoning the hearing mean in circumstances where it's something other than the judgment? Because otherwise you'd be inviting the court to need to make a decision on jurisdiction other than by a judgment, which, my Lord, I would say would be a rather constrained way of reading it. And indeed, my Lord, I think that's also would be a surprising construction in circumstances where, and you can see this, my Lord, from the expert evidence, I don't need to take you to it, in circumstances where, as a matter of practice, the Dubai courts regularly only render judgments on jurisdiction bound up with the merits, my Lord, and that comes from the Dr. Bin Hazim's report, my Lord, at paragraph 7.2.8. My Lord, so there's evidence on that. So that, my Lord, I think really is a submission on that point.
But it follows from this submission, does it not, that, for the sake of example, on the 12th of January 2015, when your clients issued their claim in Sharjah, the DIFC claim having been issued 3 or 4 months earlier, there was then a conflict of jurisdiction which engaged the jurisdiction of the USC.
My Lord, yes.
It's a quite remarkable proposition.
Well, my Lord, I think our proposition would be there are two requirements. Your Lordship will see this in issue 2A and 2B in my skeleton. The first requirement is that that the requirements of Article 60 be made in relation to the conflict of jurisdiction. But the second requirement, my Lord, and one can see this in Article 60, paragraph 3, the need for there to be the filing of a petition. But also, because neither party filed...
Well, that's just the points of claim. I mean, the writ, the summons, whatever it may be called.
My Lord, indeed.
So your contemplation is that Article 60 is entirely engaged by the action and decision of the parties, in which the court has no involvement at all.
My Lord, no. If I may take issue with your Lordship's suggestion in that regard, we would say it's not that the court has no role in it, because of course the court may refuse to register a claim. First point. Secondly, the court...
Sorry, who may refuse to register the claim?
Well, the court's registry, if a party failed to comply...
Well, all right. I mean, I can see that it may say it's not in proper form or something like that. But assuming the writ is issued in Dubai and the writ is issued in the DIFCC, there is then, you say, as from that very second, a conflict of jurisdiction, because one party has decided to go to one court, another party has decided to go to another court, and immediately the USC Article 60 is engaged, and people can then go off to the OSC, staying the proceedings in both the DIFC and the Dubai courts for presumably a pretty long time, until the USC hands down its decision. Is that really what you're saying?
My Lord, I would say that, but with something added to that, which is that they have not abandoned the hearing of the action. They've not abandoned the claims of the courts.
Oh, well, you're right. I mean, they've issued the proceedings. They haven't withdrawn them. I follow that.
Or indeed,
They haven't abandoned them. They're there. They're extant. They're in the court file.
My Lord, yes.
No, it is a pretty remarkable concept, isn't it? It provides a reluctant party to litigation with an absolute godsend of being able to bring proceedings to a grinding halt by issuing in another emirate or another part of the emirate, and then requiring the USC to rule on the jurisdiction, some presumably year or so later. And in the meantime, everything is stayed. It's not a conclusion that attracts me very much.
My Lord, I understand that, but I think there was 2 points I would say in response. The first is, of course, that those courts, the first instance courts or courts before which the claim is pending, of course, may nonetheless... my Lord, may I pause for a second? I think actually the better point, my Lord, is this. That may possibly be the consequence of it, my Lord, but if we say that is clear language of that is the clear...
Yes, I understand that. Yeah.
But my Lord, but also, I would suggest this, that may also have been the thinking behind why the decree 16 of 2000, the recent decree, my Lord, may have been passed so as to obviate that risk. Because, of course, my Lord, and I say this, of course, with the greatest of respect, but Federal Law 1973 was probably not initially, prior to it being amended, as it was when the DIFC came into creation in 2004, was not envisaging a situation where there would be a plethora, potentially, of cases where there were a conflict of jurisdiction within one emirate. And it's perhaps for that mischief, my Lord, the decree is directed at. So,
can I come back to one point you made earlier, which to the proceedings that you've instituted in Dubai? What's happened in respect to that? Is there an application for challenging the jurisdiction of the Dubai courts?
My Lord, yes. Yes, there is. The other side, as I understand it, have issued...
And is that what... That is... your Article 60 application, that's the one you're waiting for today, as I understand it.
I understand not, my Lord. It's actually the ruling on jurisdiction itself.
Oh, it's the ruling on jurisdiction, not the Article 60. So you're expecting a ruling on jurisdiction. Now, that seems to sit uncomfortably with the submission you made a moment ago, that the way the Dubai courts operate is to determine jurisdiction only with the merits.
My Lord, indeed.
But it seems to me that that is not what's happening here.
It does seem like that. I also understand, my Lord, and that is something which is somewhat unusual, but more pertinent. I just understand from my learned friend, Mr.
Yeah.
In fact, the judgment has actually been adjourned. 18th of August. It's until the 18th of August.
So what has?
The Dubai court's ruling on jurisdiction
Oh, right. It's adjourned to the 8th of August.
18th, my lord.
18th, sorry.
Which...
Yeah, well, well, is there another hearing? What's the point of the adjournment? Right, okay. So what's the date of the application by the claimants to challenge the jurisdiction of the Dubai courts? I've got your application for a stay under Article 60 on the 24th of July. I'm assuming the jurisdiction is challenged before that date. Do you have a date?
I'm just looking through the chronology now, my lord. I don't know if that's my...
Thank you.
...may know his application.
Well, I'd be grateful if Mr. Abbott could help me on that when he has a moment. Yes, thank you.
Yes, Your Honour.
Okay.
My lord, yes. My lord, so we say that the claimant's position that there's no conflict of jurisdiction in the absence of two final conflicting judgments cannot be right, and we say that as a matter of ordinary language, but also as a matter of the structure of the text. My lord, one looks again at Article 60 again. I think we're still on page 123.
Thank you.
Your lordship will see at subparagraph 3 the reference to the filing of the petition shall entail the stay of the decisions of disputed actions, and then the next paragraph says the competent circuit of the Supreme Court shall order the stay of the execution of contradictory judgments. Again, my lord, we say that demonstrates a distinction between pending proceedings and judgments, so then it can't be right that it only deals with final conflicting judgments. If we're right, then it is then within the Lindsay my lord, and indeed that is further supported, my lord, by again the reference in paragraph 2 of Article 60 to official copies of the disputed petitions or the contradictory judgments, as the case may be, shall be attached to the petition. So, my lord,
I'm so sorry, where are you reading? I do apologise.
My fault, my lord. Subparagraph 2 of Article 60.
Right.
Official copies.
Yes.
So
I've got the point.
The point there is a simple one, that if it were only dealing with judgments, then there wouldn't need to be a need to submit disputed petitions or the contradictory judgments. That clearly, as the case may be, that clearly demonstrates, my lord, precisely the point that the jurisdiction of Article 60 is invoked, even absent a ruling from the lower courts. Else, why would there be a need to put in the disputed petitions in contradistinction to the contradictory judgments? That, my lord, would not make sense in those circumstances.
Okay.
My lord, we would therefore submit that the structure of the text and the arguments I've already made demonstrate that it's in fact the invocation of the jurisdiction between the two judicial authorities that falls within the not abandoned hearing, my lord. And if I may briefly, in that case, my lord, turn to two decisions of the Union Supreme Court in this regard, very instructive. The first one, my lord, is case 1028 of 2002. Just bear with me just one moment.
It's divider 13, I think.
Yes.
Yeah.
And
It's the passage on page 134.
my lord, indeed, yes.
Yeah.
Your lordship clearly is ahead of me on this again. So, my lord, the point there is my lord, is clearly, as it explains about 2/3 of the way down the page, the meaning of his text, that the state of disputed jurisdiction doesn't exist unless jurisdiction is disputed between the federal that it recites Article 60 and then goes on to say where each of them claims its jurisdiction to hear the case or give up its hearing, or each of them issues judgment in the case that contradicts the other. My Lord, again, we say that falls within that tripartite distinction which I've drawn in relation to Article 60.
Well, what the court is saying there surely is they're looking for a conflict of judicial authority where both authorities claim jurisdiction, or both authorities give up hearing the claim, or both authorities issue a judgment.
My Lord, yes. But the question I would ask, my Lord, and I appreciate it's a rhetorical one, is how does the court claim its jurisdiction other than issuing a judgment? If it claims its jurisdiction, the way in which we say that happens is by the court accepting the claim. Because otherwise one will be looking for a category of claiming jurisdiction separate from judgment and separate from issuing the claim.
Well, because jurisdiction issues arise before determination of a claim, usually. And so you can have a dispute about jurisdiction, entirely interlocutory dispute, in which the court jurisdiction is challenged and the court nonetheless allows the matter to proceed and, as might be said, claims it has jurisdiction to hear the case. Alternatively, they may go on to a full merits claim and issues a judgment.
My Lord, yes. But it might be also that the court would issue a judgment in relation to jurisdiction as well, which I think certainly from an English...
Well, they might, yeah.
It might also. So if the court were dealing with issuing a judgment on jurisdiction at an interlocutory stage, then what would it mean, my Lord, for a court to claim its jurisdiction other than by rendering a judgment on jurisdiction? And that's the issue.
Well, it can't mean, can it? A court claims jurisdiction if a party issues a suit.
And it has not
Can't mean that.
That
All right.
is
Hasn't withdrawn it. I follow that.
My Lord, yes. Or indeed,
So as I say, all he does is issue the suit. And that, you say, that's a judicial authority claiming jurisdiction.
my Lord, yes. Because
I think that's difficult. Very difficult.
My Lord,
Okay, well, I understand the point.
I appreciate that. But we say that's consistent with the structure of the text.
Yes.
My Lord, and if we can perhaps look in that case to how this has been looked at subsequently by the DISC courts, and your Lordship will see, and I've made these points at paragraph 63 onwards of my skeleton. Your Lordship will, well, if I may go to
Sorry.
so Your Lordship,
What do you want to look at?
well, my Lord, what I was saying was that is our explanation of that report. The Lordship will appreciate, though, that there's an issue as to what case 1062 actually said, because, of course, there's an excerpt that's quoted from in Allianz, which is somewhat different, and perhaps we can briefly turn to that.
Yeah, let's look at that. Okay.
That's at that my Lord's at tab 16.
Yes.
Page 150. And your Lordship will see there paragraph 28, where the court says, even though the rules of the Constitution are silent, this has been considered in case 1028, and there's an excerpt there from case 1028.
Well, it's not easy for me to get involved in a translation dispute. As I understand it, His Excellency Justice Ali Al-Madani had in front of him the Arabic version of this decision. Is that right?
Well, my Lord, that's what my learned friend says in his skeleton. But I
Oh, right. You don't know.
I don't see that from the judgment.
No, okay. Anyway, he is, of course, by definition, an Arabic speaker, and therefore in a better position than I to. But I take your point. There is a perhaps rather striking difference between this passage and what we've just been looking at.
My Lord, yes. My Lord, yes.
Yeah.
And that's essentially my submission in relation to Allianz and IGPL, which my Lord also...
You make the same point there, yes.
The same point there, that it relies on the same thing rather than the certified translation here. And of course, I say with the greatest respect, my Lord, obviously there's obviously something there gone wrong in the translation. But we would say your Lordship ought to, to the extent your Lordship needs to, and it may be your Lordship doesn't need to, because it's only this case, my Lord, where there's an active petition. But to the extent your Lordships need to, I'd invite you not to apply Allianz and IGPL.
Yeah, okay, well, let me just have a look at this. Yes. Well, then it's binding on me, isn't it?
Well, it is binding, my Lord, except these statements are obiter because there was no active petition before the Union Supreme Court in neither Allianz nor IGPL. They were dealing with a different set of factual circumstances, so it's not strictly binding, my Lord. And I appreciate your Lordship is not going to want to go down the line of suggesting this is some kind of quasi determined by the per incurium. But nonetheless, I would say your Lordship's not required to follow them in this limited obiter regard.
Okay. Now, what do you say about Maidan?
My Lord, yes. Perhaps we can turn to that. That, my Lord, is at tab 17 at page 226. And again, there's two translations in here as well. And your Lordship will see at page 226. There's the quote there, and there's a reference at the outset, my Lord, to there being a negative conflict of jurisdiction.
Yeah.
We're not dealing with here. And then the reference to the positive conflict of jurisdiction arises when two judicial bodies, before both of whom a dispute is brought in respect to the same subject matter, assert jurisdiction based on their remit. Neither judicial body gives up jurisdiction and justifies recourse to the challenge. Now, that clearly explains both the negative and the positive conflicts of jurisdiction which may arise, but notably there's not mentioned there judgments, so it's clear that is also captured. My Lord, now the claimant's expert, Dr. Habib al-Mullah, and the claimants say that the sentence which starts neither judicial body, which the Lordship will see, neither judicial body gives up jurisdiction, is not itself an independent basis, my Lord. And one can see that briefly at 759 of the expert's report.
I'm nearly there. 7.5.9, no.
My apologies, page 59, my Lord. Page 59, paragraph 20.
Yeah. Thank you.
And I invite your Lordship to read paragraph 20. And my Lord is going to quote over the page from...
Yes, I have that.
A different translation, which your Lordship
right.
will see. So, my Lord,
I mean, it is a different translation, but is it? Is there any significance in the difference?
We would say not, because again, it talks about negative jurisdiction and positive jurisdiction. Again, there's no reference to judgments.
Thus, justifying an application to the court competent on matters of conflict. However, this requires the existence of a dispute pending at the same time before two courts, both of whom confirmed jurisdiction to entertain such.
My Lord, yes. And
So what the emphasis is being put on, I think, the verb assert, isn't it? It's the court that's asserting jurisdiction, not the party.
My Lord, yes. Save again that I appreciate your Lordship may not be with me, but my submission would be that other than by rendering a judgment, by which I mean a jurisdictional judgment, of course, not a judgment on merits, other than rendering a judgment, the court, how does a court assert its jurisdiction other than permitting the party to continue with its claim and therefore has not abandoned the hearing of the matter?
Understood.
Great.
Thank you.
My Lord, by contrast, our expert, again, you can see it's at tab 6, just before we are at page 45, my Lord.
Yep.
Paragraph 7.2.4, he sets out there three
Yes.
which he gets from the case law, simultaneously pending, asserted their jurisdiction, which is your Lordship's point, both failed to decline or give up, which is the point I'm making, my Lord. So, my Lord, we say that what's required is that there be simultaneous proceedings where jurisdiction has been asserted in each. And given that Article 60 can be engaged, even though the lower courts have not yet issued judgments because of the not abandoned hearing limb, the question then comes, what does asserting jurisdiction mean? And my Lordship already have my submissions on that. So we would say...
We're just turning over the page, if we may, to paragraph 7.2.7.
Yes,
Professor or Dr. Habib Azim first of all says that although a final judgment is not required, it would be sufficient to have a clear indication that each has not abandoned jurisdiction. My view is supported by the third requirement as set out in the USC by the Maiden City matter, which indicates that each of the judicial authorities must decide whether or not they decline their claim to jurisdiction after the matter is referred to the USC. Now, I'm not sure I'm following that. I mean, I'm not sure what a clear indication means, but equally I'm not clear how it is significant as to what happens after the matter is referred to the USC. Anyway, there we are.
Well, my Lord, yes.
Okay.
Which is why I think our position would be it's the invocation of jurisdiction that's perfect.
Yes, well, that I've got that very much in mind from your skeleton at paragraph 53, I think. Yeah.
My Lord,
Thank you. Thank you.
My Lord, so we therefore say that there is a conflict of jurisdiction within the meaning of Article 6.
Yes.
So turning, I don't intend to deal with issue 2b, this is paragraph 68 in my skeleton in any detail, because I don't think it's in dispute. Your Lordship the petition and the certificate.
Yes.
And the exhibit to it.
Well, that doesn't seem to be a live issue. Maybe it is, but I don't think it is. Yeah.
My Lord, no, indeed, my Lord. So as a result of that, our position essentially is, and your Lordship sees that there at paragraph 71 of my skeleton, that if the preconditions of Article 60 are met, we say they are, then once the petition's been filed, and this is an excerpt from Dr. Habib al-Mullah's report, it therefore requires a stay of proceedings of the competing courts until the issuance of a decision by the Supreme Court, the competent court, my Lord. So in those circumstances, well, those are my submissions. As I prefaced at the outset, we do have observations to make in relation to the suggestion this claim is an abuse, this application is an abuse of process. But I wonder if it might make more sense to deal those very briefly after my learned friend has made his submissions to your Lordship.
Yes, I agree with that. Thank you very much indeed.
I'm grateful.
Thank you very much. Right, I think we might have just a short break, if we may. Mr. Abbott, just to complete my timetable, what's the date of your application challenging jurisdiction of the Dubai courts?
My Lord, I'm being helped by my learned friend here. I think the